Assalamu alaikum everyone and good morning. This video is about Qawaid Fiqh or known as legal maxim. This video is about sub-maxim under maxim hardship, which is need, general or specific, is treated like necessity. First of all, what is Qawaid Fiqh? Qawaid Fiqh is about general which can be applied in various cases that comes under ruling things. Qawaid Fiqh has played an important role to humanity since hundreds years ago until today. There are 5 major maxim in Qawaid Fiqh, which is: all matters determined by intention. Certainty may not be disproved by doubt. Hardship begets facility. Harm must be removed. Custom is a basis of judgment. These maxims form because there are many new cases appeared one by one since the death of Rasulullah, peace be upon him. In past, Rasulullah, peace be upon him, is the one who make decision. But today Rasulullah, peace be upon him, is no longer, therefore there are jurists who will make the decision in the place of Rasulullah, peace be upon him. In this video, we will be discussing sub-maxim under the maxim hardship begets facility, which is need, general or specific is treated like necessities. Now let's begin with our topic sub-maxim, which is need, general, or specific is treated like necessities. What is mean by this maxim? This maxim denotes that a pressing need involving the ummah as whole or individual can affect changes in Sharia ruling. In some cases, Sharia also assign need status on par with necessity. Before that, it is necessary to understand the difference between general haja and specific haja. General haja grants more leeway to avail concession than specific haja. It is not necessary for a person making use of a Sharia concession granted on the basis of general haja to demonstrate individual need. That is because there are specific texts that grant these concessions by unrestricted wording. Specific haja are general texts such as those quoted as the authority for maxim 15, hardship begets facility. Thus, a concession allowed on the basis of a specific haja can only be used if the user is in a state of actual need. Since that is the case, a concession granted on the basis of a specific haja must be used only in proportion to the person's actual need. Next we will talk about the difference between haja and darura. Haja does refer as a state of hardship, but it will not result in destruction if it is not achieved. Where else darura will cause a destruction if it's not achieved. Darura makes it permissible to override the origin rule as compared to haja does not override any origin rule. Scholars disagree about specific haja being given as same ruling as darura, where darura makes a prohibited act permissible for the person undergoing. There are some contradiction to apply this maxim. First, the need must already be existent. It should not be anticipated. Second, the consideration of haja should not be at the expense of any of the essentials, daruriyat, because essentials are the basis for both hajat and embellishments. This is the reason why some scholars translate hajat as complementaries. They complement the essentials and are, thus, subservient to them.
Next, I will explain about the authority of the maxim. Since the maxim is corollary of the leading maxim hardship begets facility, the evidence for principal maxim also supports the validity of this maxim. Also, Quran and Sunnah provide evidences based upon haja, which proves that the sabab need not to reach level of darura in order to acknowledged by Sharia. From Sahih al-Bukhari, Allah's Messenger prohibited men from wearing silk. However, he granted a concession to some of his companions to wear silk when they suffered from scabies or some other itch. From Hadith, Allah's Messenger said that do not sell what you do not possess. It means that someone cannot sell something that he doesn't own. However, when Prophet came to Medina, he found the people conducting forward sales of dates with delivery for 2 or even 3 years after the contract session. He did not prohibit this transaction because there was a need for it. For example, small farmers need money for their working capital as well as living expenses before the harvest of their corn. Ibn Abbas stated that verse 282 of Surah Al-Baqarah was revealed about salam contracts. Jurists agree that salam contracts are permissible as an exception to the general prohibition of selling things that do not yet exist.
The application of Maxim 19 in Islamic finance. The general rules of contract is that the subject matter must exist when the contract is concluded. However, jurists have permitted this contract of bay'asazna. Bayasazna is a purchase order contract where a buyer make order to manufacturer for non-exist item according to specifications given. Bayasazna contract is widely been used in Malaysia, for example as in a contract of house and building. Next is application in Muamalat. Allah forbids us to eat carcass, blood, pork, and animals that is illegal to eat because it is unhealthy and harmful for human. Nevertheless, there is exception for this rules. Written in Al-Quran as well where say that humans can eat illegal food during difficult situations where they are starving and there is nothing else to eat to save their lives. Last application is in economy. Wala is an Islamic contract where the seeker of benefit offer a reward to another with conditions to achieve a specific goals. From the basic principles of exchange contract, it is prohibited due to uncertainty of contract period and amount of work need to be done. However, there is rukhsah due to people's need for it. Islamic law allows one to do illegal things during darura, however, there is some things in Islam remain illegal such as adultery and murder.